I believe we're all here, correct?
My apologies.
Thank you. Counsel? I understand the mother is taking 10 minutes?
That's correct,
That's
Your Honor. Good morning. May it please the court. My name is Valerie Robin, and I represent the mother whose parental rights have been terminated for her daughter and son. And I'm asking this court to reverse the decision and remand with instructions regarding the necessary evidence required to terminate parental rights when the parent is the victim of domestic violence. That is, when the necessity of permanently terminating the child and the rights with the mother, what's the necessary evidence? I will note that my client, if she walks in the middle, she's coming in from Springfield. She was on a bus, so just if there's, because we're a little ahead of schedule. This case from the beginning was about mother's unfitness because she was a victim of domestic violence. More specifically, this case is about a single domestic violence incident occurring almost 4 years by the time the trial ended. That same domestic violence incident that formed the basis of removal formed the basis of termination of mother's parental rights about 4 years later. Once the mother got the children off to school that day, she called the police, recorded the domestic violence incident that had happened earlier while she was in the car with her husband and the small children in the back seat. DCF arrived after the police, and she told DCF when they arrived she didn't want to get a 209A order because the last time, which involved a different abuser, he tried to kill her. From that, DCF commenced the action and removed the children. And what happened to these children, separated from their mother, separated from each other, and placed in 15 different plus placements, can't be ignored in the context of this domestic violence case involving a victim. The crux of this case was mother lacked insight into the effects of domestic violence on her children. The problem, nonetheless, with this case is the evidence. Mother's unfitness wasn't tied to drugs, mental health, or housing, or that her
Counsel,
husband...
can I just probe that a little, because there were mental health issues here, and there were, if I'm remembering the case correctly, 2 suicide attempts. This is not merely about domestic violence.
I would suggest, Your Honor, that this case was primarily about domestic violence.
It may primarily have been, but there were other aspects to it.
The other aspects, including the mental health, the evidence was lacking. Most of the evidence came from the mother's diagnosis of what her mental health came. Most of the evidence came from the judges telling the mother not to worry on the stand, but then later finding that she lacked some emotional stability during this Zoom trial. I remind the court that the mother attended every hearing, including these Zoom hearings, with one exception when she had a Denson's. She was present. I also remind that the evidence was such that for the first 6 years, mother was involved with DCF. She was caring for these 2 children. That included IEPs, that included working with the nutritionist, that included going to doctor's appointments, getting them the necessary services. And despite the multiple 51A reports, they always found that she was okay. And then what happened with this domestic violence, and this is what I would ask that this court, because we have the custody of Vaughn, which speaks very specifically about the specific findings required when you're going to place the child, when you're going to make a custody determination and place the child with the abuser. Here we have a victim, and shouldn't this victim, when you're going to take away her parental rights, shouldn't the court be required to specify what the impact is? I'm not arguing that domestic violence is somehow good for children. I'm not making that argument. But what I'm saying is tie it specifically to these kids and what's going on with these kids and the impact of that domestic violence in their life. That wasn't done here.
Wasn't the evidence of active abuse against at least the son?
No. There was no, as a matter of fact, the evidence in the record was that there was no physical abuse as to the children, none whatsoever. And there's nowhere in the record, as a matter of fact, the record supports it, and I cited in my brief, that there was, I'm not minimizing father's action, but you still have a mother and you still have a victim, and when she didn't want to get the 209A order at the time of the incident, they took the kids away. And from that, the next 4.5 years, these kids went on this odyssey where you have to look, we're trying to protect the kids, but are we protecting them when we're taking them away and putting them in a situation? The boy that you mentioned, in the middle of, after he's been separated from his mother, is caught in the middle of the night running away. I mean, he was 7 years old at the time, running away in the middle of the night. We all know that if that son was in mother's custody at the time, we'd be taking the child away. But nonetheless, what I'm asking very specifically is, we have a great body of law when substance abuse is involved. We say there has to be a nexus. We would never take away a child from the non-alcoholic parent without explaining why the non-alcoholic parent remaining with that abuser would be a problem for the child and safety is. In this case, by the time of trial, what was the evidence? The evidence was mother wasn't, and DCF concedes this, wasn't living with the father, hadn't been living with the father since July of 2020. There was evidence that you talked earlier in the cases about cell phone. There was evidence that she still shared a cell phone plan with the father. So therefore, she wasn't separated from the father. There was evidence that when she logged in on one of her Zoom, the Zoom ID was of the father and not of, that didn't say her name. I mean, I've been doing Zoom arguments with this court, and we always have a little chuckle of some of the IDs, little Johnny's iPad. So my point is she was in therapy, and again, like, we need a body of law that explains when domestic violence, particularly where the mother's the victim. I mean, we do have several cases from the SJZ about the complex situation of domestic violence. I mean, the victims have PTSD. It's hard to separate from the abusers. And we also know from the custody of Vaughn is that it's too important of an issue to ignore. But somehow, because we weren't giving custody to the mother, we didn't really necessarily need specific findings. And I think that that's what I'm asking for this court. And then if the mental health, which you asked at the beginning, was such a crucial thing, where's the evidence? Put the evidence forward. And there was no evidence forward. And that's the problem with this case.
Counsel, how do you address the reality that we're now, if I'm counting correctly, 5 years down the road?
That's a real problem with these cases, right?
But it's a problem in a lot of TCF cases that we see. The children, from all appearances, are well placed at this time. There is evidence of bonding with the pre-adoptive parents, and after some hand-wringing, the children are on this side of the podium at this time.
Well, I'd actually would beg to differ. Children's Counsel submitted a supplemental affidavit with placement, which shows once again the placement of the older daughter, whose birthday was yesterday, so she's 12 years old, has now been placed 3 more times, and there was a problem with the pre-adoptive. So I don't know that the kids are necessarily better, but I do also know something else, is at the end of this case, what happened, notwithstanding the appellate process, and I think this is on DCF, is they had mother say her goodbye visits. So they set the things in motion. So as we know, the appellate process is a lengthy process. It takes a while, and it's no fault of anyone standing here, but it's just the reality. But now, I do believe, this is the 2 little kids, what was clear from the record was there was strong bonds with their mother. And I'll leave it to Children's Counsel to address this, but I'm not 100% convinced that they're appropriately on the right side of the fence from reasons, and including what's in this docket. Because if you remember, there was a motion that perhaps a hybrid be, but that didn't happen. So I do believe, though, if this court is going to, or the trial court's going to be removing the act of the most sacrosanct, this started at the removal, and it never got better. And I don't think that the kids, which is why I think you can't look at it in isolation with the mother. I think you have to look at what's right for these kids. That little boy ran away. I mean, he was removed at 4.5 years old. And imagine the tenacity of a child at 7 years old to run away. Now, the record is replete that somehow was mom's fault. I'm not going to go there. I'm just going to say is this mother has a right at a minimum to know, and I see my time is up, so I'm going to sit down. Has a right at,
you can have another minute.
Thank you. At a minimum, has the right to know why. She might not be the most articulate client. There's in the record there was cognitive problems right from the beginning, from the very first petition, and they're wondering why mother doesn't understand the harm of her being with the abuser as it impacts the kids. Well, how about the court, how about DCF explaining what that harm is? Specifically, not this general harm that domestic violence is bad. We know that. We know living with an alcoholic is bad. Yet there's thousands of kids that live with alcoholics. But the question becomes is, does that impact? And there's a balancing. Anyway, if they have any further questions.
Thank you very much, counsel. We'll hear from Father's counsel.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the father in this case. I want to reiterate the position that Father took in the brief I filed, that he is not contesting his unfitness. Instead, he is supporting the mother's request for a remand and reconsideration of the termination of her rights. I want to use my argument time to reiterate much of what counsel for the mother said. I think that the juvenile courts are really in need of guidance from the appellate courts about when it is constitutionally permissible to terminate the rights of a victim.
Before you go there, can you address the standing issue?
Yes, Your Honor. The father has standing. Adoption of Douglas makes it quite clear that even a parent who has stipulated to his or her own unfitness or concedes unfitness at this stage of the case through the appeal of the case has the right to promote a placement for the child. In that case, I believe it was a particular kinship placement, but it shouldn't be any different when the placement is with the actual parent of the child. So I believe it's pretty clear that from the SJC that the father has standing. So, and when the primary concern, as it was in this case, is domestic violence and the parent is a victim of that violence, I think we need clearer guidance from the appellate courts of how to deal with that. I think custody of Vaughn gives a good example of how it could be dealt with. There, in order to place a child with a perpetrator of domestic abuse, the court needs to make specific and detailed findings about the effect of the abuse on that child or those children. Similarly, when the parent is the abused party and domestic violence is the primary concern, specific and detailed findings about the impact of the abuse on those particular children would be important to prevent a parent being penalized for being a victim of domestic violence by losing custody of his or her children, and for the children being penalized by having their rights to an otherwise loving parent severed. And part of that, as counsel for the mother argued, part of that analysis should be to weigh certainly custody of Vaughn makes it clear that domestic violence in the home wreaks a feeling of insecurity for the child. But similarly, being removed from a parent creates insecurity, and there's no better case to show that than this one, where the children were in multiple foster homes. They've never been placed together since the very beginning of this case. And as counsel for the mother asserted, the supplemental appendix shows that the older child still has no permanent home. And at age 12, I think we have to face the reality that there may not be a permanent home for her. So in terms of the court's concerns about that, a remand to the juvenile court to at least make those specific and detailed findings about the effective abuse on these children, on whether the mother still has any meaningful relationship with the father, whether the mother has been the victim of domestic abuse since she has disconnected from the father. All of those things would be important to get the right result in this case, because just as we should not place children with domestic abusers without really examining the impact on those particular children, we should not remove children and terminate parental rights based on a parent's victimhood. If you have no further questions, I'll.
Counsel, thank you very much. We will hear first from DCF.
May it please the Court, Jeremy Bayless for the Department of Children and Families. This is a case involving mother's long-standing pattern of relationships with violent men, going back to the father, and the relationship was in with her oldest child, who was removed from her care years ago and is not part of this case. She testified at trial that he was a violent and dangerous man. We continue then through to this case. Mother is involved with father, who is violent to her in the presence of the children. Mother's description of what happened on that event varies several times throughout the case, but she admits that he did strike her. Shortly thereafter, roughly a year or several months later, father's arrested for punching mother again. Mother testifies at trial that she doesn't see any benefit to participating in domestic violence courses because she already knows anything that she needs to know about red flags or the risks of domestic violence, but when pressed, she could not articulate to the court that what those red flags are. Mother also has a longstanding history of mental health concerns. The diagnoses that mother testified to at trial are certainly evidence the court can consider, as was the court's observations that mother struggled with managing her emotions in stressful situations. This is a struggle that didn't only happen at trial. In 2015, while the department was investigating reports that the children had been, one of the children at least, had been sexually abused by mother's brother, mother admitted that she became overwhelmed caring for the children, that at one point she had at least once struck the 2-year-old son in the face because she was becoming overwhelmed by his behaviors. Mother's inability to sort of safely and productively manage her emotions was relevant to be considered by the court in determining whether or not she was going to be able to care for children who have relatively significant needs. The boy's been diagnosed with oppositional defiant disorder. He was diagnosed with autism. Both of those diagnoses did not happen in mother's care. They happened in the care of later caretakers. But to sort of move from the mother's failings, it's important to look at the domestic violence piece as well, because that's been a large focus of.
Now, part of the argument that you're hearing is that the evidence, the sort of non-stale evidence, was just thin. Although the point isn't really pressed, how much of this is potentially driven by COVID and the COVID procedures and the lack of DCF hands-on involvement for a period of time?
It's not clear, and I hesitate to seek refuge there because it's the department's burden to present evidence. it being hard to get that evidence can't really be held too much against mother. What we know, though, is that during this period, mother had several years of moving from state to state and city from city, claiming that she was living apart from father, and then 2 months later, she's moved to live with him again. Father's in North Carolina, mother lives in North Carolina with him. He moves to New Hampshire, then immediately goes back to North Carolina. They've got a long relationship of things that would indicate separation only to be followed by reunification. Then we get into the body of the care and protection proceedings, and mother's still moving around separately from father, then back with father. Mother is attending meetings with father, leaving with father. Mother at one point in, I believe, July 2020, testified that she and father had decided to live separately, but that they were still together, and that once she regained custody of her children, she could see him back in her life. And so that's the information the court has when assessing it. So while there were no instances, no police responses, no reports that father had struck mother for a while at the time of trial, there was an indication that mother was not appreciating the domestic violence risk. She was continuing to claim that father was not violent and was not a threat to her, but she hadn't engaged with and learned from the services to identify what could cause that, what might put the children at risk were they to be returned to her care. Not to be disparaging of the children, but children can be difficult. And 2 children that mother struggled with when she had them the first time would be put back into an environment where mother struggles to regulate her emotions, struggles to respond appropriately, and is, per her own statements to the Department of Social Worker that the that the judge credited, seeking to renew a relationship with father upon the event that they're returned. So the judge has to make the determination of what does she think is going to happen. And that's based on pattern rather than things happening immediately before. The abuse, in light of mother's ongoing evidence of entanglement, if not romantic relationship, was enough to support the judge's determination that pattern of engagement and that pattern of risk of exposure to violence had not been broken.
How do you address counsel's argument that the case law is missing a nexus case in the context of domestic violence?
Well, I guess I wouldn't agree that it's missing. Vaughn and Lilith lay out pretty clearly that witnessing abuse is harm, which is different than your nexus cases with with substance abuse. Parents can use drugs in a way that doesn't harm the children. They can do it when they're not around them. They can do it, and some people are high functioning. It doesn't necessarily impact the care. But Vaughn goes into detail, and I put at least one of the quotes in my brief about how the act of witnessing violence in a space where you are supposed to be safe is harmful for children in and of itself. And it's not an obvious harm the way that being left alone or a dirty house or experiencing being physically abused is harmful. It is a soft harm that can be difficult to manage. They no longer feel safe. They no longer feel secure. They can be anxious. And when you're looking at children when we look at them having behavioral issues and acting out, we don't know what the cause of the ODD diagnosis is. And it's difficult to make those findings when we know that there is this harm that they were witness to that causes anxiety and difficulty. Obviously, domestic violence doesn't cause autism, but it could have, but witnessing that could be something that influences that as well. So Vaughn and Lilith do lay out the harms that happen to children when they're around domestic violence, and it is a different sort than being with a parent who abuses alcohol, or a parent who abuses other substances, or the other areas where there need to be direct findings as to the nexus. The nexus is that witnessing violence is a harm to the child. And conveniently, I see my time is up. If there are no further questions, then I'll rest on my brief.
Thank you very much. We will hear from each of the children.
Good morning. May it please the court, Roberta Driscoll-Weiss on behalf of the child Lexus, who is the oldest child that was referred to earlier. I want to apologize for my tardiness. Again, I was in the study room preparing for this argument, and apparently Attorney Bayless and I had a similar train of thought going because he stole my argument. This is not a case about a single episode of domestic violence, and this is not a case of a woman's single relationship with a violent man. This is a case about this mother's repeated engagement with violent partners that served to interrupt her relationship with her children. She lost her oldest 2 children, who are now adults, who the record made clear she had not seen in many, many years, despite living something like a mile away from the guardian. She lost those 2 children because the relationship that she was in at that time was a violent one. That man broke her ribs. She referred to that man as a dangerous man. And yet, she then became involved with father. And there are 2 documented incidents of domestic violence, at least one of which we know occurred in the presence of the 2 children. The department offered mother specific services to address domestic violence. They offered her a healthy relationships group. And mother declined to participate in the healthy relationships group because she said it was only to make DCF happy. It was only to make her look good. She didn't believe that she would obtain any or derive any benefit from that healthy relationships group. And perhaps had she attended, she might have learned what we've all been talking about here today, that the impact of domestic violence on children is insidious. It's not the same as physical abuse. It's not the same as being struck with a belt. It's something that festers. I mentioned in my brief some research that comes from the Harvard Women's Law Journal that talks about the impact of witnessing domestic violence on children who then become adults.
But this piece wasn't introduced below, correct?
It was not, Your Honor. It was in my brief to support my argument.
I think what I'm getting to generally is, are we to take judicial notice of this harm? I mean, what counsel says there should be more specific findings of the harm.
My client was in a pre-adoptive home as the supplemental appendix that I filed, which I am a little unclear as to how to proceed because it was accepted for filing, but the order said the propriety of which would be left to the panel. But if I could refer to the information in that supplemental appendix, my client was in a pre-adoptive home for roughly a year and was removed due to behavioral concerns. She was then placed in another foster home and right now is no longer in any sort of pre-adoptive placement.
But we're familiar with I believe we're familiar with the record and the facts, but I think the link between the impact of the domestic violence and the travails incurred since then. Are we missing the evidence to establish that connection?
I don't think you are, Your Honor. I think that there's case law that says that the court doesn't need to wait for terrible things to happen. They can act sort of in anticipation of harm. And I think that this is not just a case of domestic violence. This is a case of a mother who was engaged in violent relationships and did
Well, we're
nothing to-
focusing on the domestic violence portion now. There was one offense reported October 2017. That was the incident in the car.
That was the
And then the
incident.
mother reported another incident that she was assaulted December 31st, 2019, correct?
I believe there was an incident in December 18. There was a police reference to a police officer's information.
And the trial was some years later, correct?
It was, Your Honor. With respect to the 2017 incident that gave rise to this case, mother denied that there was that any domestic violence had occurred in the car, as did father. Mother attended the temporary custody hearing with a black eye, which the judge did take notice of. I think to expect a trial court to be able to spot specific harms stemming from domestic violence puts a burden on the trial court that is unfair. And I say that because these are these incidents and the effects of observing domestic violence may not be seen until adulthood, when something like 20%, 79% of violent offenders in an institution reported having observed domestic violence as a child. it may not be something that we see right away, like a bruise or a burn.
I think, and I want to speak for my colleagues, I'm more interested in what was before the judge, and what evidence should be before a judge, and all these things you're citing weren't before the judge.
I'm sorry, Your Honor. What was before the judge was that the department offered mother a variety of services to address the wide range of parenting deficits that she had: mental health issues, domestic violence, housing instability, and substance abuse. And mother did not avail herself of those services until, I think, December 2020 is when she enrolled in therapy. We know that failure to comply with services is evidence of unfitness. So even if we don't have a direct causal or a result, or the resulting harm that we can point to with these children to say that witnessing that domestic violence caused this specific issue, what we do know is that this was an individual who came to the court with a number of different matters that needed to be remediated to address her parenting, and she did nothing toward any of those.
I think we're going to have to leave it there. Thank you very much. We'll hear from the son.
Your Honors, Tamika O'Brien on behalf of the youngest child, a young boy. Your Honor.
Could I just ask you briefly, and
Sure.
I neglected to ask prior counsel, the position of your client?
Sure. So when I came into this case, I was successor counsel. And there was some discussion about whether or not this child would want to file a hybrid brief because of his position on visits. I got to know him.
Not on termination, just on visitation?
Correct. It was on visitation. I got to know him, and we talked, and his position ultimately, and I know this because we met, and then we did a couple of FaceTimes, and then he called me back. Well, the foster pre-adoptive parent called me, and I stepped outside of where I was, and he said, he wants to talk to you. And a lot of times children do this. You know, I always tell them, if there's something you want to talk to me about later that you didn't think about right now, call me back. And he did. And he said, I want visits on my terms. And I want visits on my terms. And, you know, we had discussed what that meant, like a court-ordered visitation versus visitation on his terms. And this is something that we really worked through. And that is how I came to the position that this would not be a hybrid brief after all.
Now, your client, unlike his sibling, remains in a pre-adoptive placement?
Correct. And I wasn't able to go out and meet with him, but I did do a FaceTime with him yesterday just to make sure, because, you know, children change, things change. And so I talked to him yesterday and just wanted to clarify his position, and it remained the same. Your Honor, I don't think that I have a whole lot to add to the domestic violence and the nexus issue, but what I think is really important to talk about is what was the evidence before this judge and how it reflected on mother's ability to to parent my client, who was diagnosed with some pretty significant issues. And at trial, mother said she thought it was important that the children have structure and routine. Yet when she parented these children, they never had a set bedtime. And that might be a little thing, but it leads to an indication of the chaos that was in this home. And she testified that, you know, she would take him to the park and doctor's appointments, but she was never able to say where he would go to school or who the physician or pediatrician would be. She wasn't able to maintain that kind of structure and routine in her own life. And that is really telling that, you know, we always talk about when you're in an airplane, you put the mask on yourself so that you can take care of the people that you're with. And I think that it was pretty clear the evidence before this court is that mother was not able to put that mask on herself. She wasn't listening to the advice of her therapist, who said, this healthy relationships group will help you. She wasn't willing to, and my time has expired, I see, but if I may finish my thought.
Yes.
She wasn't able to do the things that were necessary to be able to put herself in a position to parent this child specifically. And for that reason, Your Honors, we're asking that.
Thank you very much. Thank you all. We appreciate not only your experience and competence in this matter, in these matters, but also the sensitivity you have all shown to this difficult situation. The case is submitted. Our next and final case of the morning is Gazelle versus Gazelle, 2022 P829. Podium, please.
Good morning, Your Honor. Victor Tice on behalf of the appellant, Aicha Gazelle, and with me is my colleague, Patrice Morris. Thank you very much for having us here this morning. We're here this morning on an appeal of what we believe was an abuse of discretion on the part of the trial judge on a discrete but significantly impactful part of this case.
Before you go into it, which is very well briefed, could you clarify what you're actually appealing? Because the notice of appeal on its face reads mostly like an appeal of the underlying judgment, and yet it followed the denial of the motion to amend the judgment. Are you seeking to appeal both, or just?
Both, Your Honor. We believe this is something that should have been rectified via the Rule 59 motion, given the clarity of the issue. The significance in this case hinges on this conversion rate, because you have a significant asset of the parties that's valued in a different currency and a significant income stream attributed to our client that's also received in a different currency.
Okay, but just in terms of framing the issue, the valuation of the, I'll call them the Istanbul assets,
Yes.
Is in U.S. dollars is ultimately a question of fact, it would seem.
And that would be our point. We're not contesting the judge's determination of the value in Turkish lira.
No, I'm talking about U.S. dollars, though, because.
Correct. And then it becomes simply a mathematical formula, and the critical.
Well, we'll get to that in a moment, but it strikes me that to prevail, you would need to show one of two things: that the valuation of the assets in U.S. dollars was clearly erroneous, or that the judge abused his discretion in denying the motion to amend the judgment. Isn't that the proper way of framing this case?
In part, yes. I'll deal with the Turkish assets, the EDLR units. If they have a value of 12 million Turkish lira and that's determined, then the critical component becomes what conversion rate do you use and what date do you apply. The judge's rationale did not provide a date of conversion or a conversion rate. He just simply put it in U.S. dollars, and you had to reverse engineer the conversion rate.
I'm not sure that's accurate, counsel, because, I mean, if you're correct, the judge didn't say a lot. But what the judge appears to have done is to take the appraisal reports, take the conversion rate at the time of the appraisal reports as the general matter, but then used a somewhat hybrid approach where he, on the mortgage, the amount of the outstanding mortgage, he used the October 2017 rate, and then subtracted that value from the appraisal value and then split the difference between the two appraisal reports.
So I don't believe it's accurate that he used the appraisal value. That was .3411 at the time of September 2016. He blended it and created, because his average, if you note, when you went and broke down, I carefully broke down each conversion, they weren't unanimous. And this is something where at the end of the day, there's a closing rate for the currency. So it's a known quantity. There should be no such thing as a hybrid conversion rate. There is the conversion rate. International markets depend upon these conversion rates. Many billions of dollars of goods are traded based on the precision of those conversion rates. So you don't just create a hybrid one. You don't average it. It is what it is. That's why you can take judicial notice of it. That's what the judge did. You can't judicially notice something that's a creation of your own. That's not a fact. That's something the judge created. He came up with the hybrid number of .3363.
He didn't say that.
He didn't, but that was the effect of what he did.
Correct. I hear you.
That's my problem, is he didn't explain or give any rationale, and when you look at the mathematical outcome, it's not justifiable based on the fact, and the problem is, it was even before the trial started, and just when you look at the trial start date, and as I noted, day 4 of trial, there was only a 4% drop in the conversion rates. However, that yielded a $120,000 delta. That's not insignificance to these parties. So it highlighted how
4% as compared to what?
So on the
Talking
first,
about 2016 to 2017?
on the first day of trial on October 3rd, 2017, it was .27733. On day 4 of trial, it was .26916. That difference in those amounts yields $120,000 more. If he'd chosen day 1 of trial, the asset would have been worth more. By day 4 of trial, it was worth approximately $120,000.
Tell me if I'm wrong. Your real beef, as it were, is that there was 3 years between the beginning of the trial and the judgment.
Correct. And the trend
And over
line,
that time, the lira started to fall.
well, the trend line of the chart clearly showed that that trend had been years in the making. Exhibit 39 clearly indicated.
Yeah, yes and no. It unfortunately for all of this, it was pretty stable around the beginning of the trial. It had gone down, it was pretty stable, and then it went down again.
But
So I suspect the parties weren't particularly focused on this issue, given the relative stability of the lira in October of 2017, and the fact that no one anticipated it would be another 3 years before they saw a judgment.
I don't think we would have called it that stable, because as I pointed out, just that little delta between day 1 and day 4 yielded a significant outcome. When you looked, the only...
So why did the parties stipulate to this very impressionistic look at how the exchange rate was changing over time?
So the parties stipulate to the fact of the exchange rates.
No, in fact, with 2 a year in 2017, 3.
Again, for simplicity's sake, you could break it out daily, weekly, monthly, annually, and the negotiation in any trial, biannually, and it still showed a significant trend line. What it puts on notice is there is a sharp drop-off. For example, if you looked at the date the complaint of divorce was filed in 2013, July, it was over 0.5. If that was the case, applying on the alimony side, our client would be getting $4,111.
Yeah, but...
Whereas on October of the trial date, it's down to $2,100. That's a significant loss.
Well, yes and no, because, I mean, to figure out the value of these assets in U.S. dollars, I think we all can agree, you take their value in lira, you multiply it by the correct exchange rate,
Correct.
and you get it. So it's X times Y equals Z.
Correct.
And you say, let's focus on X. And the husband points out, they're not talking about Y. In the 3 years between the beginning of the trial and the judgment, if, for example, Turkey were experiencing great inflation, Y may have dramatically changed in a way that would offset the reduction of X. And we don't know that. And your brief, as elegant as it is, basically says, just ignore Y. Let's not think about how Y may have changed.
I really believe the way to view it is the Turkish lira is the fixed number. It's 12 million and it's 7,000.
Why is it a fixed number? You want it to be fixed.
No, the judge found it fixed. The judge said this asset's worth 12 million Turkish lira. So if it's worth 12 million Turkish lira in 16, 12 million Turkish lira, we're saying 17, 12 million Turkish lira in 18.
Can I interrupt for a moment? You know, my poor father was a math instructor, and so he'd be embarrassed to know that my head is spinning, right? Because to me, and maybe I'm viewing this too simply, it's like when people get divorced and the house was worth $450, and then at the end it's either worth $250 or it's worth $1.2 million. It's when you make the valuation, not whether the lira is worth 0.2. Sure, that complicates matters here, but to me, it's like your retirement fund. It's like your home. It's assets. It's when you viewed the value. Some days a house is worth X. 3 years from now, it may be higher, it may be lower. But is it error for the judge to say, this is when I am going to value things? Forget about all the fancy schmancy lira and conversion. It's just the market. It's when you divide assets, they're not always worth the same thing. Sometimes they're better and sometimes they're worse. So had it been a boom, maybe we would have a different appellant saying this isn't fair because, but we don't. I mean, so isn't it just when the valuation snapshot happened that you claim is the unfair nature?
I think I try to distinguish between the speculative nature of appreciation, depreciation, inflation, deflation, which are very hard to quantify. This is extremely quantifiable because every day there's a final closing conversion rate, and you can plug that into the mathematical formula and come up with the outcome. So if a judge picks a value date pre-trial, and at the very start of trial, it's already dropped by 10%, that's a significant factor that needs to be accounted for because it's not worth $4 million. At the start of trial, there's no way it was worth $4 million because the very beginning of trial, it was under 0.3, it was 0.27. So it had already been a significant diminution in value from the date the judge said of September 16. That needs to be accounted for. And then on a 15-month trial, 2 years to a judgment, when it's so simple to simply look at a conversion rate and apply it to the mathematical formula, I think it should be done. And the real key, though, becomes to the alimony part. Because when you're saying someone's getting net Turkish income of 7,920.66 Turkish lira a week, that's not worth $2,131.92.
What if, as a result of inflation, the rental rates in Etile, or however you pronounce it, went up so that the X times Y would produce the Z of the same amount as under a different exchange rate?
It would still, the exchange rate would still slot down and diminish the value. The closing value yesterday was 0.0514. That's $400 US. So her rental income.
But we don't know what the rental income is.
The judge did in his findings. It's not contested.
Based on evidence of what it was presumably in 2016 or 2017.
But that's the evidence he said. He said she gets $2,132.16 a week. That's just not true. She only got that on one particular day where the conversion rate yielded that number. Any other day, she doesn't get that amount. Any other day, she gets the conversion rate for that week. And if the conversion rate falls below 0.2, she's getting $1,000 a week, not $2,100. And her whole alimony was set on a need of $188,000 a year.
Could you shed any light on the 3 years it took between the beginning of trial and the judgment? Because the real problem in this case is the dramatic time that...
It was a complicated trial with international witnesses. Trial time was scarce, so I can't account. That's unfortunately out of our hands as trial lawyers. We always want things to move faster. A 15-month trial in no one's best interest. And as to the 2-year delay in the judgment of it, all we can say is we inquired, requested. Each side was anxious to get it, and it took what it took. It's a difficult position as a litigant to push a trial judge to issue something, and it took an extraordinarily long period of time. But as to alimony, it's a constantly moving target. But it's an easy remedy because when the Turkish lira is fixed as the judge fixed it, and that's not being contested.
The husband argues, this may or may not be accurate, that in the context of the trial, the wife was looking for a fixed amount of alimony, and the idea of indexing the alimony to the exchange rate only came up after
It's
trial.
not indexing, it's a factual reality. 7,000, I'm just going to be speaking rough math, 7,000 Turkish lira is only worth 2,000 US dollars at a discrete point in time. 6 months later, it could be worth $1,000. That significantly impacts our client if she's not getting the 2,000 that the judge assumed she was getting. The judge predicated his alimony on her receiving 1,500 from husband and the rest supplemental by her.
When was this argument about whether you call it indexing or just tying it to the exchange rate in some fashion, when was this first raised?
It was, the moment we saw the judgment, we instantly went to the court and said, you failed to account for the exchange rate as you should have. It would have been patently obvious that you can't fix a dollar value on a foreign asset and have that be set for in perpetuity because it changes all the time. I just got back from Europe and Portugal, and just when I was there, my rate changed daily, and my bank kept telling me, do you want to accept this conversion rate? So it's an absolute fact, judicial notice is taken of it, that the currency rates change, and it could significantly impact both pro and con the amount of support received. And if it's not acknowledged and dealt with, someone's going to win and someone's going to lose in an unfair fashion because it's so easy to fix. All you have to do is look at the conversion rate and say, my God, if it's fallen below 0.1, she's not getting anywhere near $2,100. She's so short of the math, now she's not even coming close to her marital need of $188,000, all of which was in US dollars. And so when an income stream's in foreign currency, you've got to convert it so that it's apples to apples, because right now it's apples to oranges.
Okay, your time is up. I, for one, still have some questions, and my colleagues may as well. If the wife was concerned about the falling lira, there are different ways that could have been addressed, including, for example, doing what they did with the Bodrum assets, which is to have them, order them sold and the proceeds divided. Alternatively, the wife could have said, no, I don't want these assets, give them to the husband, along the lines of, you know, the old aphorism, one kid cuts, the other kid chooses. I see no evidence that the wife tried to pursue those other means of ensuring equality. Is that an accurate?
As to the asset division, that's accurate. These had tremendous sentimental value to our client, but I don't think it excuses setting a rational date for conversion and valuation. And what the judge did in setting a pre-trial date without explanation of his conversion rate wasn't fair and accurate. Even if you just taken the first day value, it would have been significantly lower and affected the true-up, so to speak, in the differential asset values ascribed to the parties. So it really, as far as we see, there were some key dates, either the first day of trial, the last day of trial, or the day the judgment issued. And you can see the tremendous difference in those, and there should be some explanation as to why you would pick one over the other, particularly where it's a 15-month trial.
Getting back to Judge Walsh's question, was there any requirement as a matter of law that the judge choose the day of the judgment as opposed to some other
case law is
point?
clear. The judge is granted just tremendous discretion, but where there's evidence showing a significant trend and a downward slide in the exchange rates, where the judge did take judicial notice of some, it would have been so easy to just look it up and say, wow, if this is continued down on that slope, why is it fair to set it at a trial date, the first day of trial, where the appellant has no ability to liquidate the asset, no ability to do anything with it because of the automatic restrainer on assets, and now she's tied to a value that she can never achieve or utilize or realize, and there's some equity would say, let's pick a fairer date, look toward the end of trial and see what it is. And if you saw the tremendous drop, when it gets over $1 million, I think some explanation is owed and required as to why you would choose an earlier date when the appellant, through no fault of her own, couldn't exercise that value in any way, shape, or form.
Okay, last question from me. Your argument is dependent on the judges taking judicial notice of the exchange rates, which, as you know, the judge did with respect to some of the dates on his own. And I grant you, there are a lot of cases that say that you can take judicial notice of exchange rates. Why wouldn't the same be true with respect to inflation rates?
I don't believe inflation rates are as solid and defined as conversion rates. There is more mathematical fluctuation. There's more estimates on rates of inflation. It's not as, it's a complicated formula, whereas the conversion rate is simply based on the overall trading that happens on that day, and the math runs itself out at the end of the day. So many trade forth, back and forth. At the end of the day, the conversion rate happens based on what happened that day. It's a much more solid number. I don't believe.
So if we were, for example, to look at IMF charts of relative inflation rates during the relevant time period, you're saying we shouldn't take judicial notice of them?
I'm saying it would be a more complicated analysis and a voir dire of the underlying math behind it. There are approximations of inflation rates versus, getting into the true algorithmic math of how you calculated that is far different than a currency conversion rate that's relied upon by thousands and thousands of traders on a daily basis.
Okay. Thank you very much. We will hear from the husband.
Thank you, Your Honor.
May it please the court, my name is David Lee, and attorney Kimberly Joyce is with me, and we represent Guy Scott Gazelle. Your Honor, what is at issue in this appeal is the integrity of law and the legal process. You're asked to change the law dramatically. You are asked by the appellant to in fact find that the trial judge committed error by relying upon the evidence before him, making findings of fact based upon the evidence that was presented before him, making a rationale explaining why it is he entered the judgment that he did, and then entering a judgment which is fully supported by all of that. The word that is the key word, I think, to focus on in this case is evidence. What is it that was before the court that the court could rely upon in making a determination of what it is that should be done in this case? Not what it is that might occur after the evidence closed, not what it is that might be the changes that occurred for whatever reason among any of the things that are relevant in this case, that occurred afterwards, including even the exchange rate, but what it is that was before him. And he did that. And at no point in time in the 2 years between the close of evidence and the entry of judgment did the appellant come before the court under Rule 59A and seek to reopen the evidence or to suggest that, in fact, the exchange rate had some bearing upon what it is that the judge may be contemplating.
Is that fair, counsel? Because there was a point before evidence closed in which counsel went first, I don't know if it was you at the trial court or not, but went to counsel for the husband and said, we want you to stipulate to the updated exchange rates. And the husband said no. And then they went in front of the judge and said, Your Honor, the exchange rate is plummeting. This is important. We want you to take judicial notice of this. And the judge said, I'm going to, after a day of thinking about it, said, I'm going to deny this for now, but I may revisit it later. So the issue was raised when the record was still open that the judge should be using updated exchange rates.
My comment, Your Honor, is that the dialogue that went on between counsel at that time and the court evidenced that the appellant had no intention of introducing any evidence suggesting.
But why did he need to produce evidence in the usual sense, given that there's case after case that recognize it, that not, as it turns out, from Massachusetts, but elsewhere, that courts can take judicial notice of exchange rates because they are pretty settled and accepted as, you know, if you do your taxes and you get foreign income, you look at the table, you figure out what it's worth in US dollars.
What I was about to say was that there was clear indication from the appellant's counsel that they had no new evidence to present that the exchange rate had any bearing upon the value of the Turkish assets, and that the exchange rate in and of itself was not a determinant of value. The only evidence that was before the court was the expert testimony indicating what it is that the value was in Turkish lira in 2016. No suggestion that there was going to be any attempt to introduce any evidence, nor over the course of the 2 years before judgment was issued was there any effort made to try to reopen the case or to present any evidence to suggest that the Turkish lira value that was testified to by the experts had in any way been altered by the change of the exchange rate. So the nexus of exchange rate to value was never suggested or shown to be of any relevance in the case. So that, I believe, answers the question with respect to the valuation of the Turkish assets. And as I commented, I believe in the brief, that with, in fact, the decline of the US dollar or foreign currency relationship to the Turkish lira, that could have resulted in a dramatic raise of value. And we can't do anything in these cases other than rely upon the evidence that is presented in these cases. As Justice Walsh commented upon, after a judgment is issued, it could very well be, and even during a period of time from the close of evidence, it could very well be that there are increases in the housing rates, there are increases in interest rates, there are increases in inflation, there are changes in the economy all the time. But if that is not introduced in evidence, the court cannot rely upon it in making its judgment. And that's why I say that what's being asked of the court is a dramatic change in the law. And that is to rely upon what it is that may occur after the evidence is closed to suggest that error has been committed by the court in relying upon what the evidence was and the connection between the evidence and the value at the time that the matter was presented before the court. On the issue of alimony, this was a case where there was a critical issue not merely of what the amount is that should be paid in alimony by Dr. Gazelle with a spouse who had no income. One of the critical issues in this case was what was the level of income that Ayça Gazelle had. And that took up a lot of time in this case. And you will notice from the very beginning in the record, in 2013, when she first went into court asking for support to be issued, the judge at that point in time, we had 4 judges over the course of this case, found her to be incredible, her financial statement to be incredible, because she indicated she didn't have ownership of property, she indicated she didn't have any income, she indicated she didn't have any dividends or interest. And through the course of this entire case, she continued to misrepresent to the court, continued to omit representation required to be made to the court, resulting in the court even commenting in his rationale upon her manipulation of her own income. And she did something dramatic in this case, which the court commented upon, which I've never seen before, and that is that she took the court-ordered form for her financial statement, and in order to try to change and reduce the level of her income, she changed the wording of the form. The wording of the form says, as one of the permitted expenses against income, bank interest paid on mortgages. She changed that to just say mortgage payment. And in the course of doing that, she built in, of course, the amortization of principal, which was not what the form calls for. And she, in fact, included mortgages that she was paying interest on, which related to an assumption of debt that was her brother's debt, not her debt. And there are at least 10 findings by the court in this case that are included within pages 40 and 45 of the Record Appendix, Volume 1, where the judge indicated very clearly that, in fact, what she did was unbelievable, and how it is he had to struggle with finding out what her income was because of the failure on her part to accurately represent her expenses. So when we talk about it being simple, as suggested by my brother, that all you have to do is look at a chart and apply math. This case presents a situation where any word other than that is what it is that really is relevant. Not simple, not easy. Instead, complex, difficult, a struggle. Because in dealing with alimony, you're dealing not just with the income of the payor, you're dealing with the income of the parties. And in fact, the income of Aisha Gazelle was a focal point of this particular case, and her manipulation of her income was critical.
Counsel, I hear what you're saying. I'm not sure if the judge would have concluded that this was a model of propriety or decorum on both sides of the V.
On the issue of income, absolutely, I would believe the court would find that, because he found it over and over and over again in his multiple findings. Remember something as simple, even in this case, in his finding number 2, I think on page, well, I don't know the page of the Record Appendix. He found that she didn't even represent accurately the number of her marriages. She had never told her husband before that they were married the number of her marriages. And while she testified that she had 3 marriages, the evidence showed and the judge found that she had 4 marriages.
Counsel, concerning alimony, is it your position if the income stream of the wife fluctuated either significantly upward or downward, then the avenue to relief for either party would be a modification?
Absolutely correct, Your Honor. And that is what everybody else in a divorce case has to do. They have to go before the court when they want to change, and they have to show that, in fact, there has been not just a change, but a material change. And not just a material change of circumstance, but they have to show that it warrants a modification.
What if, I realize this is not established by this record, but hypothetically, what if her entire income was a fixed income? That it was a pension whose amount wouldn't change going forward? Wouldn't the exchange rate then determine what the value of that pension was in U.S. dollars? The value of the income stream, I mean.
I don't really want to argue a totally different case, but I want to answer your question. And I'm going to answer it in a way that you're not going to appreciate, which is going to say it depends. And when I say it depends, I say that because of the fact that the law makes clear, and I think the Young case identifies, that requires a showing of special circumstances.
But why wouldn't those
By
be
a
the
judge.
special circumstances where, again, assuming a fixed income in lira, then to determine what the value of that income stream is in dollars, the only really factor at issue is the exchange rate?
While I would say to Your Honor that, in fact, if a court were to do that and made findings that under the particular circumstances of that case, like in the Stanton Abbott case, something of that sort should be done, it might not be found to be erroneous. But I do say this, there's nothing in our case law that says that the failure on the part of the court to enter a judgment that did call for some self-modifying impact is error. And I would say that in a case where the court failed to include a provision which provided for the adjustment that you suggested, it would not be error for them to have failed to do it unless there was special evidence that indicated that it warranted that being done.
Could you address or flesh out what you say in your brief that during the trial, the wife was looking for a focusing on a fixed amount of alimony.
What I meant by that, Your Honor, is if you look at the proposed form of judgment, the wife, in her proposed form of judgment, asked for the payment of $3,000 a week, which is the amount that had been set back in 2015 by the judge who issued the temporary order, again, under this manipulated financial statement that was issued by her, that was presented by her at that point in time. And I think that that was a circumstance. I'm not sure that I answered the question directly.
No, it did.
Yeah.
It did, actually.
But I think that that's where it is, that not only did she fail in her proposed judgment to ask for, not only did she specifically ask for a fixed number, but she didn't ask that the number be adjusted at any point in the future, either with respect to the value of the real estate or with respect to the support. And on the last issue, the issue of reimbursement, the judge found here, related to the manipulation by the wife, that there should be an adjustment made in the alimony he had been paying for a period of time from 2015, but indicated that since he couldn't put himself in the exact position that the other judge was in 2015, that he was only willing to provide for a reimbursement that was effective as of the close of evidence when he heard all of this manipulation and the failure of representation, the omission of representation, and the misrepresentation of the wife's income.
I have a final question, which I think is appropriate with the red light exhibiting as well, is I, like many in this region, are indebted to Tom Brady. It's difficult to monetize that debt, either in lira or U.S. dollars. Your client was able to establish a $10,000 debt. Was it ever on the record as how that debt was incurred?
How the...
There was another Tom Brady, there was a reference.
I'm sorry. I had forgotten about that completely. That was a gentleman named Tom Brady who was not...
Oh, it wasn't TB12.
Sorry?
Wasn't TB12. It wasn't the quarterback.
No.
Okay, thank you.
Thank you very much. We submit.
Thank you both. The case is submitted, and that concludes our session this morning. Our thanks to the court officers and the law clerks for